Does my half of the marital property have to go to my surviving spouse?
So Keith, we see this question from time to time, and that has to do with maybe a spouse that doesn't like their other spouse so much. They've been married too long, maybe 30, 40 years, and they don't want to give their one half community to their surviving spouse if they pass away. We also see it in blended families where two people who've had separate families and then they get together and get married, they've got different lines of kids. And so the question is, hey, do I have to give my spouse everything that I have, or can I save it for my kids? So how do you respond to those questions?
Well, in California, every spouse is allowed to give away their half of the community to whomever they like. It does not have to go to the surviving spouse. They also can give their separate property to whomever they like. It doesn't have to go to the surviving spouse. So they actually have quite a bit of leeway. Now, what you can't do is you can't give away the other spouse's half of the community property because that belongs to the other person. So you can't do that. The problem we run into is twofold. Number one, even if you want to give your assets to somebody other than your surviving spouse, if you don't do proper planning, there's a good chance that won't happen. So a lot of times people will do things like put their home in joint tenancy. Well, if you have your home in joint tenancy with your spouse, the entire interest in that home, 100%, is going to go to the survivor. That's how joint tenancy works. It doesn't matter that it was separate property at one point. It doesn't matter that it was community property at one point. It's going to go to the survivor. So it's very important that you understand planning and plan properly. Number two, it's not always clear cut what's separate property and what isn't. And so a lot of times people will assume that, well, this is my separate property. But if it hasn't been handled properly, especially in a long-term marriage, you could start getting fuzzy lines as to what's community, what's separate. And that makes a big difference, because if you can give away 100% of your separate, but only 50% of your community, that could have a big impact on who gets what at the end of the day. But the bottom line is you can give your assets to people other than your surviving spouse as long as you're only giving away your part of that estate.
So the end story I'm taking away from this is you do not have to give everything to your surviving spouse. You have the ability to move your one half of your interest in the community property and all of your separate property to whoever you like outside of your spouse.
That's correct.
You can also give it all to your spouse.
You can too.
Okay.
Yes. Albertson and Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson and Davidson, LLP.